Well, in the light of some of the exchanges this morning, I would respectfully suggest we should go back to the Court of Appeal's judgment to see exactly what the Court of Appeal was doing. So can I ask you...
Before we do that,
Yes.
can you just remind me what your Proposition 7 was? Because I didn't get that down.
Yes.
I mean, we may come back to it.
My Proposition 7, my Lord, was that the rules of international law on which Ukraine relies can only have relevance to a domestic law right, and thus can only be a domestic foothold if those rules have been or should be incorporated into English domestic law in some form.
Thank you.
And could we go back to paragraphs 159 and 160 of the Court of Appeal? And so I pointed out that at paragraph 159, the Court of Appeal, the last sentence, when they said this provides a sufficient foothold, there we're simply saying, well, because there's a doctrine of duress in English law, which Ukraine's allowed to plead, that provides the sufficient foothold. In my submission, that's a misunderstanding of what is meant by domestic foothold. But if we go on to what they did decide, they then say at 160, and you see they jump into this morally or socially unacceptable test. So they then say it's true that Russia and Ukraine are sovereign states, which means that the test for what might count as morally or socially unacceptable in the context in which they interact is not the usual one appropriate to relations between private parties. But the authorities make clear that the English doctrine of duress does not turn on breach of domestic law as the criterion of illegitimate pressure. The notion of illegitimate pressure is wider than that. Although moral and social standards are more attenuated in the relations between states on the international plane than is the case in purely domestic commercial contract, international law sets out reasonably determinate standards of conduct applicable between states on the international plane. In our view, there's no reason why the law of duress should not treat these as providing an appropriate test of illegitimate pressure in the present case. Now, if we break that down, what the Court of Appeal firstly has done is say the fact that you're pleading duress gives you the domestic foothold. But what they haven't done, and as I explained earlier, is to say, well, does that mean we can decide or treat breach of the international law? And let's take as the paradigm example the threatened breach of customary international law prohibition on use of force. Are they saying, well, that is something which is unlawful as a matter of English law? Plainly, they're not. But what they then go on to do is to say, well, we have a test of morally or socially unacceptable. They recognize that doesn't actually make any sense in relations between states. So what they then say is, oh, well, it's more attenuated, but international law sets out the standard of conduct applicable between states. So all it's saying here, I mean, if one actually, that's why if you broke out the analysis and the court had said, right, and if we take the allegations in paragraph 21, the threatened use of force, is that something which is relevant as a matter of English law? Is it a breach of English law? The answer in my submission would plainly be no. Then can you repackage it and say, well, it's not even repackaging it. Can you simply then say, oh, well, international law, which we don't treat as part of English law, sets out the reasonably determinate standards. It's just, in my submission, doing by this route exactly what you don't do when you're asking the question of incorporation. So,
well, but they are doing something different. I mean, admittedly, the law on the English law on what counts as illegitimate pressure might be said to be in a state of development, and there aren't very many authorities, particularly authorities at this level. But that's what they're focusing on in the first sentence of 159, the issue of illegitimate pressure. And what they're saying in 160 is that conduct, that international law, although not relevant to establish what is unlawful under English law, provides standards for judging whether behaviour has constituted illegitimate pressure under English law.
Yeah, that's
the argument.
That is what's being said,
Yeah.
and my riposte to that is that you have to ask yourself, well, why isn't it unlawful as a matter of English law? And it's not, I think it was being put to me earlier, well, we have cases, and as your Lordship says, this is a developing area of jurisprudence, so I recognise ultimately you're the Supreme Court and you can do what you like. But if one's going to try and develop this area of law in a way that is consistent with our approach to these rules in international law, in my submission one has got to first start by understanding why we haven't incorporated, for instance, the international prohibition, the customary international law prohibition on use of force. And I would suggest that one does get to a very odd situation where you say, well, we will effectively treat it as part of English law for this purpose. What one has to remember, if you draw a distinction, if one thinks about what CTN and cases like that are saying, is that it's unsatisfactory where conduct is strictly legal, but you can see somebody's taking advantage in some way. And in fact, there are no English cases where the conduct has not been somehow linked to something unlawful. You saw that in the decision of Mr. Justice Cook. I mean, there had been a repudiatory breach of the contract, suggestion that they would compensate, and then they try to force the charterer to waive their rights.
There seem to be quite a few cases about variations of contract which are negotiated on the basis of effectively a threat to break the contract.
Yes, exactly. But what we're talking about here is it's not an area where what one is saying is, well, the conduct is regarded as legitimate as a matter of English law. That's the mistake. It's that this is conduct in respect of which the English court, English law, does not have a view, because it's conduct on a different plane with which English law doesn't in any way engage.
So the central mistake, if I'm following the argument, is in treating international law as setting standards of conduct for the purposes of our domestic law.
Yes, absolutely. And and it's very important to understand that's the reasoning of the Court of Appeal in this paragraph. Now, and I then wanted to just go back to the points on the pleading, because what is very important in relation to this case in our submission is that the court does engage with what is pleaded in this sense, that if we go back to the pleading which is in Core Volume 2, and the defence starts at page 8823, if we take, for instance, and I'll come back to the points that your lordships were making against me this morning, but if you take paragraph 21 of the pleading at page 8834, that is, you can see that there it's alleged the Russian Federation's public statements in offering to support partitioning of Ukraine were, and you can see, contrary to customary international law and or Article 2.4. Now, in our submission, those matters are not relevant to English law, and they simply can't be short of incorporation. So that what is important in my submission is that one has got to engage with the pleading, even if one came to the conclusion there were bits of it which were not dependent upon breach of international law, then that's all that would be left as part of the case. So if we start with paragraph 21, in my submission, that's sort of plain, is just doing exactly the sort of thing that was tried to be done in Gentle, in Al-Haq. Your Lordship will remember that's the case about in the Palestinian territories about the wall. I'm going to come to it, but I suspect everyone's familiar with those cases. And if one then goes back to paragraph 19.1 and paragraph 20.1, insofar as there are threats which are supposed to be trade-related matters, those, if you take away the treaties, in other words, if you said, well, I'm not alleging breach of trade treaties, one would have to ask why it's in the pleading, but if one struck it out of the pleading, then it's very difficult in our submission to see what independent life these allegations have. Because in order, for instance, to say that this was spurious, what you were doing under a trade treaty, you have to the court would have to construe the trade treaty and decide, what does the trade treaty mean? What does it allow? Does it allow you to, I haven't personally looked at them, but does it allow you to impose restrictions just for whatever reason you want? All of that is engaged. And the point I think that my Lord Lord Carnwath made, well, what about paragraph 18.5 and 18.7? Now, those, certainly the way we have read them, are all linked to the trade treaties. Certainly there's no pleading of any obligation to supply gas other than by reference to trade treaties. And 18.7, if that is intended to be some freestanding allegation of, procuring breach of contract, it doesn't actually say any of that, because, for instance, it doesn't actually explain whether the Russian banks had a right to call in loans of the Ukrainians. So simply put in that way, it's very difficult to see what the alleged threat is. And that's why, of it being unlawful, it's all linked to the treaties. Now, what I'm going to do, but I'm going to try and do it quite quickly, because I think your lordships certainly have our submission and understand the point about the cases where the English courts have not treated international law or customary international law as part of English law. One case I did want to look at with you, which is relevant on the domestic foothold, or explain, is Butte's gas. And now, as with most of these cases, we're all very familiar with them, but Butte's gas is in Authorities 1 at tab 2 and MS 227. And this is it's actually, of course, Butte's gas was before the jurisprudence had developed with the discussion about the relevance question and the suitability question in those terms. But if you remember, Butte's gas, what in the headline terms were, Butte's gas was a libel case, and of course a defence in the libel case was justification. Now, just stopping there for a moment, that libel may give you a domestic foothold, because if your defence is, it said you behaved in such and such a way, and your defence is it's true, and in proving it's true, you're going to have to rely on some international law. It's not that English law is incorporated, it's just part of your defence in proving it was true. Now, the interesting thing about, that I would suggest is a fairly obvious statement, but it's quite interesting to see the observations that Lord Wilberforce made more generally in this case, because you'll remember, as well as the justification plea, it was also alleged, by way of counterclaim, that there was an unlawful conspiracy. And if we could just have a look at one or two passages, or if I could draw your attention to them. At 9.3, 3.8, page MS 277, I apologise. At E to F, His Lordship, Lord Wilberforce, was explaining the problems of the plea of justification by Occidental, which raised the same issue as the conspiracy counterclaim, which he said wasn't capable of being entertained. And in those circumstances, a problem might arise if Butes were to insist upon the action proceeding. To allow it to proceed but deny Occidental the opportunity to justify would seem unjust. Now, just stopping there for a moment, so that's why the case is referred to and was referred to below in the context of this, a stay question, so that if one comes to the conclusion, as they did there, that there is a defence of justification, but it's not suitable for determination by the English court, one can say that's potentially unjust, and so you get to a conclusion where you would stay. Court didn't have to decide that in that case because it was all by agreement. But what I wanted to then draw your attention to was what he says about conspiracy, which is on page 276. And on page 276, His Lordship at G refers to, you see he says, or just above that, perhaps at F, where it starts, if Occidental is to succeed in either its counterclaim for conspiracy or in the slander action, it's necessary to show these actions were brought about by Butes, more exactly by a fraudulent conspiracy between Butes and Sharjah. This certainly involves an examination of the motives, exclusive or dominant, for the action of Sharjah in making and, if proved, backdating the decree. It involves establishing that the actions, at least of Sharjah, and it appears also of Iran and Her Majesty's government, were at some point unlawful. Unlawful in this context cannot mean unlawful under any municipal law, but under international law, as Mr. Lauterpack put it, involves deciding whether the Sharjah decree was inefficacious, at least for a time, in international law. If in the absence of unlawful means it's alleged that the action taken by Sharjah was predominantly to injure Occidental, I'm not convinced they make that case, but I'll assume it, this involves an inquiry into the motives of the ruler and a suggestion he invited Iran to enter into an arrangement predominantly to injure. Now, just stopping there for a moment, in my submission, where His Lordship was dealing with unlawful and saying that this conduct would be unlawful not under municipal law but under international law, there he was recognising what I call the relevance question, that unlawfulness under international law wouldn't do. And that's why he went on to consider, well, what if they're making an intention to injure conspiracy? And that's what he's then considering at the top of page 277. And he then there, says that this would give rise to interstate issues. They're not issues on which a municipal court can pass. Leaving aside of all possibility of embarrassment in our foreign relations, there are, to follow the Fifth Circuit Court of Appeals, no judicial or manageable standards by which to judge these issues, or to adopt another phrase, the court would be in a judicial no man's land. The court would be asked to review transactions in which 4 states were involved, which they had brought to a precarious settlement after diplomacy and the use of force, and to say that at least part of these were unlawful under international law. So his conclusion is that this is all non-justiciable. The court can't entertain it. Now, as I say, at this stage of the jurisprudence, the distinction between relevance and suitability wasn't at the fore. But in my submission, the way Lord Wilberforce is analysing things in those paragraphs on page 277 is entirely consistent with saying that you couldn't determine that there was this motive, because as he says, there are no judicial or manageable standards. The court's in a judicial no man's land. And in other words, you come back to the international law point.
In terms of the Shergill classification, this would be in the second category,
Well,
wouldn't it?
in my submission, that's not entirely clear that it is in that second category. But of course, at this stage, as I say, his lordship hasn't analysed in that way.
But as you say, that's a case where there was a domestic foothold.
Yeah.
And the problem was the non-justiciability of the issues of international law, in the sense that there weren't any standards by which a municipal court could reach a conclusion.
What the case is not authority for is that mere assertion of an English law claim gives you a domestic foothold in the way that the Court of Appeal said in 159. And just before leaving this, of course, Belhage, which I will come back to, Belhage was not a case which concerned a domestic foothold, because Belhage was a case where the claim was that torts had been committed, namely effectively trespass to the person. And so the claimant didn't, as part of his claim, have to assert international law. What was being said was that the courts shouldn't go into this because of the suitability question, because it would embarrass the United States and so on. Now,
Can I just press you a little
Yes.
on where Lord Wilberforce, had he had the advantage of later categorization, how he would have analysed this case? And you said you didn't think it fitted into the second Shergill.
in my submission,
Are we not? Are we stuck with the Shergill categories, or are they just convenient?
in my submission, it's not simply the Shergar categories. These categories have been recognised in Gentle, Shergar, Jones.
All right, but where does this case fit in?
Well, this case is, if one's asking for, was there a domestic foothold for the justification plea? The answer is yes, there is, because as a matter of English law, you're allowed to plead justification. So it just so happens that the justification required on the facts of the case to assert that this was what happened as a matter of international law, or it required looking at international law. But it's not that it wasn't that it's a necessary ingredient of the defence that you say this is justified. The fact that in proving it's justified may go into areas of international law, that may enliven the suitability question, but it doesn't enliven the relevance question. Whereas a conspiracy to injure by unlawful means does raise the relevance question, because it raises the question whether breach of international law is relevant for an English claim of conspiracy by unlawful means. And in my submission, Lord Wilberforce was certainly recognising at 276 MS at G that as it were is the first, that's the relevance point. That's the point of what he's saying. Whereas it's more debatable when he's considering a conspiracy the purpose of which is to injure, whether that is simply, as my Lord Reid was saying, a suitability question, or whether it also encompasses the relevance question.
So how do you apply that to our case?
Well, in our case, our case is a much simpler case for this reason. The allegation is, I'm sorry I sound like a broken record, but it's necessary to break it out into the allegation that there was a threat to do something unlawful, firstly. That raises the question, is the threat to breach international law something which is regarded as unlawful as a matter of English law? So that, in my submission, just because you're saying something unlawful was threatened, that does not make the international law relevant. It only becomes relevant if international law has become part of English law. That's one of the things that one extracts from Jones, and I'll show you also comes out of Gentle and Al-Haq. Then that takes you to the second question. Well, if it's not unlawful, can we nevertheless say it is otherwise illegitimate? My submission, the problem with that is that if all that you're doing is saying, well, international law provides the yardstick for me to judge this, it is just another way of incorporating, by the back door, international law into English law. And in my submission, one really shouldn't, one should really be facing up to that.
Well, I know, but are you saying that is ruled out by what Lord Wilberforce says?
No. What I'm saying is I was explaining that Butte's gas is a case of domestic foothold in relation to the libel. Potentially, it's also a case of domestic foothold in relation to the conspiracy to injure allegation. I suggest it isn't, but even if it is, because it's saying this was something where the predominant purpose was to injure the other party, then one got into the suitability question.
Right, well. No, I understood that you were relying on Lord Wilberforce as somehow helping you in this case.
No, I've gone to it as an example. I'm sorry, I interrupted you.
No, I understood you to be reading Lord Wilberforce as saying, however you get into these issues, whether you've got a domestic foothold or not, if you discover when you get to them that there are issues which actually are not properly justiciable because you haven't got any standards in domestic law to judge them, then you knock them out either on relevance or suitability or both.
What one has to recognise is that back in 1982, the cases weren't being analysed in the way they have been more recently, so that one simply had people talking about non-justiciability, which covered both areas, both whether you have an English law right, as well as this being an area the English courts won't go into. It's only relatively recently in this century where one finds the courts analysing the case in the way I've said one has to. But if one, on this case, says, well, how does the relevance question arise? All I was simply saying to you is that this is a category of case where you don't have to incorporate international law. It's simply that you are, for libel, there's a justification defence. Conspiracy by unlawful means doesn't work. Conspiracy to injure, I suggest his conclusion was, also wouldn't be relevant, but alternatively he's saying, well, that wouldn't be suitable.
Thank you.
Can I then, just to follow the sort of scheme of my submissions, my next proposition, but we've largely covered it, is that it's necessary to take account issues of suitability in determining whether there has been incorporation. And I don't think we need to turn it up, I make that submission by reference to Jones. I perhaps should make this point about Jones under this heading. My learned friends suggest that Jones is a case just about questions of criminal law. And that is wrong. One can see that from the judgment in Jones itself, and you can also see it from Lord Mance's judgment in the KU case, which is at volume 3 of the authorities, tab 15 at 1086. The relevant paragraphs, I don't think we need to turn it up, are 145 to 146. What I would like to do is to go to two other authorities which I've mentioned in passing. The first is Gentle, which is in volume 2 of the authorities, at tab 13, page 954. And this was the case in which mother of two servicemen who'd been killed in Iraq were seeking inquests to investigate the circumstances surrounding their death, and they wanted an independent inquiry to examine the wider question whether the government had taken reasonable steps to be satisfied that the invasion of Iraq was lawful. And if we go to, it's on page 959 that you can see in the report, Jonathan Sumption QC and Philip Sales QC and Jemima Stratford's argument. And if you go to Lord Bingham at page 965, which is this is paragraph 8.2, and just below D he says, the defendants accept that if the claimants have a legal right, it's justiciable in the courts, and they do not seek to demarcate areas into which the courts may not intrude. They do, however, say, in my view rightly, that in deciding whether a right exists, it's relevant to consider what exercise of the right would entail. Thus, the restraint traditionally shown by the courts in ruling what has been called high policy, peace and war, the making of treaties, the conduct of foreign relations, does tend to militate against the existence of the right. Now, in my submission, that reasoning applies equally here, where what is being said is, we, Ukraine, say we were subjected to threats to do something unlawful or otherwise illegitimate. When the court is asking, well, is unlawfulness of these threats, is that an area that we would go into, or is that part of English law? The answer is no for these reasons. And equally, if one asks, well, can we judge, as the way Lord Sales put it, whether this is the basis, the standard for judging illegitimacy? In my submission, exactly the same reason applies. This restraint on these areas of so-called high policy tends to militate against the existence of the right, whether you call it a right to say that threats to do this shouldn't be made because they're unlawful, or threats to do this shouldn't be made because they're illegitimate.
You say exactly the same considerations of suitability arise, whether it's a question of unlawfulness under international law, exactly, or a question of illegitimacy because it's a breach of some sort of standards recognised by the international community.
I do.
Well, however you label it, what you're doing is deciding whether Russia has broken its obligations under international law.
Yes, exactly. And if you imagine in in Gentle, if one tries to put the arguments that are being, or the approach that the Court of Appeal took here, what it will lead to, where this is an attack obviously on the United Kingdom government, will lead to attacks where one says, well, I'm not saying I am entitled to actually determine the question of international law, but it's relevant as part of deciding whether you've behaved properly, whether the UK government has properly gone to war. In my submission, it creates all sorts of problems. And Al-Haq is a very good illustration of this. Al-Haq is in volume 13. tab 126. Al-Haq is a case that's interesting on all sorts of...
It's a page number.
Yeah, I'm sorry, my lord. It's page 5410. Al-Haq is interesting on all sorts of levels because it's the case concerning it actually concerns Operation Cast Lead in Gaza, but it also goes into the question of the wall that Israel has built. So if you go to 5411, you can see at paragraphs 1 to 2 that the claim was brought by a non-governmental human rights organization seeking a declaration that the United Kingdom government was in breach of obligations under customary international law in respect of the Israeli government's Operation Cast Lead in Gaza. And it's worth just noting at paragraph 6 the allegations against the State of Israel. So you see at 6 that they were alleged to be in breach of peremptory human rights norms through the nature and intensity of force. International law recognizes the right to self-determination. Occupation of Palestinian territory is unlawful, it was submitted. The breach of obligations have been extended and intensified by Operation Cast Lead, and that involves breaches of the peremptory norms of self-determination and non-acquisition of force, breaches of the Geneva Convention, and at 8 to 9 were the claims which were made against the government of this country. And in the judgment of Lord Justice Pill at 5422, you can see he's dealing with incorporation of customary international law. And then he sets out his conclusions, and he sets out at paragraphs 41 to 46 why this, the problems that this creates. And you see at 41, about 5 lines down, the subject matter in the present case is at bottom the conduct of Israel and whether that state is in breach of its international obligations. The need on this application to assume facts doesn't permit the court to ignore the claim in substance is for condemnation of Israel, for the courts of England and Wales to decide whether Israel is in breach of international obligations, and so the extent and nature is beyond their competence. Then he picks up the point that unlike Kuwait, which we'll need to look at, this isn't a case where the breach of international law is plain or acknowledged or clear to the court. The Wall opinion considers different issues. Then at 44, he makes the point it's for the government to decide on its international obligations and how to comply. And 45, the case is readily distinguishable from those in which a claimant is asserting a readily identifiable right, such as a right in certain circumstances to claim asylum or a fair trial. The claimant purports to assert a right, but in deciding whether that right exists, it's relevant to consider what the exercise of that right would entail. Constitutionally, the conduct of foreign affairs is exclusively within the sphere of the executive. While there may be exceptionally situations in which the courts will intervene, the case is far from being one of them, and so on. Now, in my submission, just going back to the point my Lord Reed was making, that it would cut across entirely this if what one says is, well, we can consider Russia's conduct as to whether it was illegitimate by reference to international law. I mean, that's doing the precise opposite of what the court here says. Mr. Justice Cranston, I would ask you to note really the whole of from paragraphs 51 onwards, but this case very clearly recognizes the the two stages, and that justiciability depends on subject matter, as he says at 53, and it notes the claim trespasses onto matters of high policy. And then at 54, in the few cases where the courts have pronounced on matters of high policy, there was what has been termed a domestic foothold. There was either legislative authorization, see Gentle, the foreign legislation in issue was in the most blatant breach of international norms, Oppenheimer and Kuwait, or the issue arose in the context of ensuring a fair trial. And then he explains that the rule about non-justiciability at 55 derives from a concern about institutional competence, and he refers to CND and sets out from Lord Justice Simon Brown. And at 56 explains why institutional incompetence, how that fits into that case. 57, he makes the point that Lord Wilberforce made about lack of judicial or manageable standards. And at 58, non-justiciability in this type of foreign relations case is also justified by the principle of comity, the accepted rule of mutual conduct as between state and state, in which each state adopts in relation to others and expects others to adopt in relation to itself. And in my submission, the mere fact that the Russian Federation, through Lord Debenture, has entered into an English law agreement does not mean that the Russian Federation would expect that the English courts would address conduct between the Russian Federation and Ukraine on the international plane. Indeed, it's precisely the opposite. And at 60, I won't read 59, but that's also relevant, but at 60 he explains, the claimant seeks to gain a domestic foothold for the court to review UK foreign policy through its contention that customary international law is part of English law, so long as there's no constitutional principle or clear statutory authority in contradistinction. But Blackstone's view that the law of nations as adopted in its full extent by the common law was penned at an earlier age on different constitutional and international arrangements hasn't survived as far as the law of treaties is concerned. Under our dualist system, these cannot confer rights on individuals directly enforceable in our courts without specific transposition into domestic law. In Jones, Lord Bingham saw truth in Brearley's contention international law is not a part but a source of our law, and agreed that customary international law is applicable only where the Constitution permits it. And that's again important. The constitutional principle there was that the power to constitute new crimes is now resolved to Parliament. The constitutional principle here, militating against incorporation of customary international law, is the one I've just mentioned. Whether customary international law should have any purchase in domestic law without specific transposition is an issue for another day. Certainly a rule that it does not would be consistent with our dualist system regarding the reception of international law. Now, I commend all of that to you. And now, so the right approach in my submission in relation to the allegations, and this takes me on to my next proposition, the right approach is to consider whether what is being alleged has been incorporated, whether the rules of international law have been incorporated. And my proposition 9 is that none of the rules of international law on which Ukraine relies have been incorporated into English law, and there is no basis for doing so now. And what I would suggest is that, and again, the Court of Appeal, with respect, also fell into error in the following respect. What they did was they failed to separate out the different allegations. So you've seen, as I explained, that there are allegations of breach of trade treaties, allegations of breach of customary international law. And you've actually got to address them separately because they actually give rise to separate considerations, because there is separate jurisprudence which looks at why certain things are and are not part of English law. So the position, for instance, about international treaties we've largely touched on is very straightforward. I mean, the cases are replete with dicta that international treaties are not incorporated into English domestic law unless Parliament so decides. And we've seen the Tin Council, for instance, on that. And in the Freedom and Justice Party case, in the authorities at 2, tab 12, the Court of Appeal at paragraph 116, so that it's at tab 12, page 915, and the paragraph I draw your attention to in particular is at page 943.
I'm sorry, I can't hear the paragraph number or the page number.
It's page 943.
Thank you.
Sorry, I think there may be a problem with my microphone.
The noise is off, I'm afraid, Mr. Howard.
115.
Paragraph, it starts at 115 and then 116.
Thank you.
They're again, I think, paragraphs that would be well known to you. But that explains as it were, the rationale behind why, for instance, unincorporated treaties don't form part of domestic law. Now, and the same point is made in CND, which I won't take you to, but that's in tab 11 of this bundle at MS 886. So, insofar as the case is based upon the treaties, in our submission that falls foul of well-established principle. And the court, as I say, the Court of Appeal simply did not deal with the treaties separately. It treated everything together. Now, then the question is customary international law, and particularly the customary international law prohibition on the threat of use of force. We've seen in Al-Haq that customary international law is not automatically incorporated, and I took you to paragraph 60 of that. And in the KU case, Lord Mance explained, it probably is worth just looking at that very briefly, in volume 3 at tab 15, page 1029. And at paragraph 149, which is on MS page 1087, 149 to 150, he considers when customary international law can be incorporated. And 150, he says, speaking generally, in my opinion, the presumption when considering any such policy issue is that CIL, once established, can and should shape the common law whenever it can do so consistently with domestic constitutional principles, statutory law, and common law rules, which the court can themselves sensibly adapt, without it being, for example, necessary to invite parliamentary intervention or consideration. Now, of course, under our constitutional settlement, issues relating to foreign policy, so acts of war, matters of that sort, are not matters that the courts can look at. And therefore, insofar as you're looking at customary international law, those are aspects which or as it were, out of bounds. And it's interesting to note that as I think I explained to you, that in modern times, the only aspect of customary international law which has been recognized is as having been incorporated is the one that was considered in the Freedom and Justice case, which was the immunity for the Egyptian special mission. So now, the position, that's looking, as it were, at customary international law more generally, but looking at the customary international law prohibition on the threat of use of force, that has been consistently denied as part of common law by the courts. We looked at Gentle in Volume 2, Tab 13, MS 954, and paragraph 8.2 of Lord Bingham. Perhaps we could just go back to that to also pick up Lord Hope. Lord Hope at paragraph 24, which is page 970. And see, the question whether the invasion was lawful was without doubt of cardinal importance to the decision whether it was proper to commit British troops to the invasion, but it was no more relevant to the Article 2.1 Convention right of each individual than the question whether it had the approval of Cabinet or Parliament. And indeed, there is a further objection. The issue of legality in this area of international law belongs to the area of relations between states. Article 2 of the Charter of the UN declares that the organisation and members shall act in accordance with the principle that it sets out. The third of these principles is all members shall settle their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. Application of the guidance that this principle offers in the conduct of international relations between states is a matter of political judgment. It is a matter for the conduct of which ministers are answerable to Parliament and ultimately to the electorate. It's not part of domestic law reviewable here. And at paragraph 38, Lord Roger was to the same effect. That's on page 973. So we've seen Jones. I don't think we need to go back to that. It's quite clear that the international crime of aggression doesn't form part of English law, point made very clearly by Lord Bingham and Lord Hoffman. Your Lordships probably have seen, we don't need to turn it up, a reference to a case called Al-Rabat in the Authorities, Volume 13, Tab 125, page 502, where the bold submission was made that Jones was incorrectly decided. Lord Thomas, the Chief Justice, and Mr. Justice Oudley said there was no prospect of this court holding that Jones was wrong or that the reasoning was no longer applicable. Similarly, we've seen in Al-Haq the nature of the allegations made there and the court's approach. So that then leads me to Belhaj, which is in Authorities Volume 1, Tab 1, page 18. And as I said earlier today, Belhaj, as the court will know. Actually, I see only my Lord Lloyd Jones was involved in the Court of Appeal. None else of your lordships are involved in it, but it's obviously a very well-known case, and it was concerned with non-justiciability in the sense of the suitability question. It didn't give rise to any questions whether international law issues were relevant to the domestic law claims, but it is a very authoritative guidance on the approach in this area, if I just make that clear, into this area of the question of whether matters of international relations are suitable and so relevant in relation to an English law right. So if I can highlight one or two passages, it's obviously a very long case, but paragraph 1, 2, 3 in the speech of Lord Newberg, in the judgment of Lord Newberger at 165. This is what Lord Newberger is calling the third rule. So you see the rules he sets out. The 121 is the rule that courts will recognise the effect of a foreign state's legislation. The second one is that recognise a foreign state's executive in action within its territory. And the third rule, at 123, has more than one component, but each component involves issues which are inappropriate for the courts of the United Kingdom to resolve. They involve a challenge to the lawfulness of an act of a foreign state, which is of such a nature that a municipal judge cannot or ought not to rule on it. And just stopping there for a moment, again, this comes back to our central submission, that one is asking oneself in this developing jurisprudence, what should the English court be saying the standard is for otherwise illegitimate in the law of duress? In my submission, it would be a paradox for the court to say that we can, as it were, incorporate questions such as interstate dealings, although the consequence of that is that one would then say, but we're not in a position to decide those questions because they're not appropriate for us. And that's very much one of the points you see here, because he goes on to make the point that courts will not interpret or question dealings between sovereign states, and quotes the well-known dicta from Lord Pearson in Nissan of obvious examples making war and peace treaties with foreign sovereigns and annexations and so on. And he then explained...
Do you say that what we're being asked to do in relation to duress would involve interpreting or questioning dealings between sovereign states?
I'm sorry, could your lordship say that?
I'm just wondering about the relevance of what Lord Newberger said in the sentence beginning thus.
Yes, well, in my submission, that is what Ukraine's allegations require is for the courts to interpret and question dealings between sovereign states. And so that when one's asking oneself, well, is that part of the English law of duress, that we can do that in judging whether the conduct is legitimate? In my submission, no, it isn't, because that is on a plane which is not, as it were, to use, I think, the word that's used in one of the cases, is not within the purview of the English court.
Do we know if there have been previous cases to do with contracts between sovereign states, and whether the courts have been willing to consider, for example, allegations of breach of contract?
Well, of course, an allegation of breach of contract won't raise these issues because, I mean, what he's talking about here are dealings between sovereign states.
I'm wondering just how wide this is.
On the international plane, that's what he's talking about. Obviously, if, for instance, if Russia, it's slightly unrealistic because the contract's likely to be between, Gazprom or some such
Yeah.
body, but if one imagined a contract between Russia and Ukraine governed by English law, where Russia said, we will supply you with X volume of gas, that would just be a commercial contract. And so you don't get into questions about public international law or customary international law or treaties. You're just in a question of, as with any commercial party, you've agreed to supply us with the gas, you haven't, or you've threatened to breach the contract to supply us with the gas, if for the purposes of duress. So we're not saying, certainly we're not saying that if a threat is made to do something which is, as it were, part of ordinary English standards, that because it's a state, the state is immune. But the question is whether what is being alleged as the conduct is conduct which is referable to an English law standard. And that is the distinction. Here, the conduct that is being referred to, and as I say, the classic one at paragraph 21 of the pleading is something which is entirely within these dicta, making war and peace treaties, annexations and cessions of foreign territory. And
So the core of the problem is that the standards by which the legitimacy of the pressure, if you like, being placed on Ukraine are to be judged according to the Court of Appeal are standards of public international law.
yes, that entirely encapsulates it, and that encapsulates the problem with the Court of Appeal's judgment. And just following through, on Lord Neuberger, I'm sure you will obviously read the rest of paragraph 1, 2, 3, and he, as with the leading judgments here were given by Lord Neuberger, Lord Mance, and Lord Sumption, and at 128 and following, so at 128, yes, he says that when the third rule has been applied in very many cases, and at 144, makes the point that there's no doubt as to the existence of the third rule in relation to property and property rights. Where the doctrine applies, it serves to defeat what would otherwise be a perfectly valid private law claim, and where it does not apply, the court's not required to make any finding binding on a foreign state. And then at the end of the paragraph, on the other hand, judges should be wary of accepting an invitation to determine an issue which is, on analysis, not appropriate for judicial assessment. And then he, at 146, explains the basis of the judicial self-restraint. Lord Sumption, if you could turn to MS page 204, at 234, he explains, unfortunately, I think the three leading judgments choose to use different labels just to confuse us. But at 234, he refers to the second principle, which can conveniently be called International Law Act of State, corresponds to the variety of foreign act of state identified by Lord Mance earlier. And he says it's that the English courts will not adjudicate on the lawfulness of the extraterritorial acts of foreign states in their dealings with other states, and there's a whole legion of very well-known cases that support that. And at the top of page 205, this is because once acts are classified as acts of state, an English court regards them as being done on the plane of international law, and their lawfulness can only be judged by that law. It is not for an English domestic court to apply international law to to the relations between states, since it cannot give rise to private rights or obligations, nor may it subject the sovereign acts of a foreign state to its own rules of municipal law, or by the same token to the municipal law of a third country. In all the cases cited, the claimant relied on a recognized private law cause of action and pleaded facts which disclosed a justiciable claim of right. But the private law cause of action failed, because once the cause of action was seen to depend on the dealings between sovereign states, the court declined to treat it as being governed by private law at all. And then he refers to Dobry and Napier, and then he says, a bit further on, if a foreign state deploys force in international space or on the territory of another state, it would be extraordinary for an English court to treat these operations as mere private law torts, giving rise to civil liabilities for personal injury, trespass, conversion, and the like. This is not for reasons peculiar to armed conflict, which is no more than an ill-defined extreme of interstate relations. The rule is altogether more general. Once the acts alleged are such as to bring issues into the area of international dispute, the act of state doctrine is engaged. Now, all of that analysis in my submission flies in the face of Lord Sale's paragraph 160. And at 237, his lordship returns to the theme. I think, because of the shortness of time, can I just commend that?
Are you saying, are all these learned judgments saying the same thing, substantially, or do we?
I beg your pardon?
Are they all saying the same thing? I'm afraid I haven't had the opportunity.
It's a very good question as to whether Lord Mance, Lord Sumption, and Lord Neuberger were saying the same thing. As I recall, Lord Neuberger, who's far cleverer than me, says that Lord Mance and Lord Sumption are saying the same thing. It's not for me to judge why it was necessary to have the three judgments, but they make very interesting reading anyway.
Good, well, thank you.
But the answer is they all, on these points, I think are furiously in agreement with each other, but they have chosen to express themselves independently and to use slightly different labels.
But if you were looking for one paragraph for the uninitiated to grab onto, which would it be?
I like paragraph 234 because it's expressed in Lord Sumption's pithy style, but I also like the paragraph I showed you in Lord Neuberger, and I wouldn't want to do a disservice to Lord Mance. And
Don't worry about that. I can sort that out for myself.
Lord Mance,
I think you've given me enough.
yeah, Lord Mance is at paragraph 95, is a similar theme. Yeah, and you'll see it, that's on page 156, and at G, after looking at various authorities, I mean, he makes the point that some matters are better addressed at the international legal level rather than in the domestic courts. And he then goes on to say, in civil as well as common law, it appears unsurprising under present conditions that domestic courts should treat acts of government consisting of an act of war or of alleged self-defense at the international level as non-justiciable and should abstain from adjudicating upon them. And he then at 107.3, this is a relevant point to pick up. An argument has been made in this case that because the prohibition on the use of force is jus cogens, that of itself means that that is incorporated into English law. And at 107.3, he explains that that's completely wrong. That's page 162, and he explains that if violation of a jus cogens were a primary test of whether a domestic court could adjudicate upon an issue which was otherwise non-justiciable and upon which it would otherwise have to abstain, central areas of abstention identified by Lord Sumption would become potentially amenable to adjudication. The prohibition on the use of armed force and on aggression are core examples. These are rightly, as would be my present view, treated by Lord Sumption himself as giving rise to core examples of issues upon which the domestic court should refrain from adjudicating. So simply asserting that this is jus cogens does not tell you anything. And a similar point is made, we don't need to turn it up, by Mr. Justice Leggett, as he then was, in a case called Al-Saran in the Ministry of Defence at Authorities 4, tab 29, MS 1549 at paragraph 111. So, in our submission, all of the allegations of international law that you see in the pleading are ones that do not form part of English law, and the same constitutional and other considerations as we see in cases such as Jones and Al-Haq would arise. And my lords, if your lordships were to say, adopt the approach of the Court of Appeal and effectively treat Article 2.4 of the UN Charter as part of English law by this backdoor route, it's difficult to see how cases like Al-Haq and Gentle would be decided today in the way that they were. Now, there's a separate point that needs to be considered in relation to the law of duress, which is this, that when considering whether somebody has a defence on duress, what you have to consider is the adequacy of alternative remedies that are available to them. So if you go down the Court of Appeals route, where they say, well, we can consider international law as setting the standard, you also then have to consider the adequacy of the alternative remedies that were available. For instance, to go to the United Nations, to go to the WTO, or to use the dispute resolution mechanisms in the individual treaties. And those sort of determinations, such as whether or not an unincorporated treaty gave rise, whether the mechanism for resolution was satisfactory, give rise to even more problems, a point that was recognised by Lord Brown in Corner House Research. And my Lord Lloyd-Jones may remember in a case called the Badger Trust and the Welsh Ministers at volume 14 of the Authorities, tab 128, MS 5494, where you declined to interpret the Berne Convention because it provided a machinery for discussion of differences, citing Lord Brown in Corner House. And in our submission, it would be absurd for the English court to make determinations about the adequacy of remedies available to Ukraine at the Security Council of the United Nations, or the General Assembly, or the World Trade Organization, or under these treaties, which have their own dispute resolution mechanisms. And just for your note, the Friendship Treaty, Article 37, has a dispute resolution mechanism, which is at Authorities Volume 19, tab 189, MS 620. The Budapest Memorandum also has a mechanism. That's also Authorities Volume 19, tab 179, MS 7450. And the CIS, the Commonwealth of Independent States Free Trade Agreement, also had one at Article 19, which is Authorities Volume 19, tab 184, MS 7472. So in our submission, one can safely conclude that none of the treaties or rules of customary international law relied on form part of English law. They cannot be the source of domestic law rights or obligations or destroy domestic law rights or obligations. Now, once one understands that, with the greatest respect to the Court of Appeal, what you can't do is effectively wave a magic wand and say, whilst these matters are not regarded as unlawful as a matter of English law and are a no-go area for English law, they somehow become appropriate for English law to consider if I attach a different label to them and call them illegitimate. In short, my submission is you cannot solve the problem of incorporation by labelling. Indeed, if a breach of an unincorporated treaty or of customary international law constitutes a breach of a standard of legitimacy, however described, then the treaty or the customary international law has, contrary to what one sees in the cases, become the source of domestic rights or duties. That's contrary to, those words come from Belhage, will destroy rights under domestic law, contrary to Tin Council. And so in our submission, none of these treaties or customary international law are capable of constituting or giving rise to unlawful or illegitimate pressure. So I've explained my proposition 10 I've largely covered, which is that the Court of Appeal's approach was flawed. I think I can probably skip over that. I think I've covered all of that. And what we set out in our written case a number of propositions as to why the Court of Appeal was wrong. Yes, perhaps I ought to just develop this. One of the points you saw at paragraph 160 is that the Court of Appeal said that there is no reason why this, that is, applying international law, was not the appropriate test. And that's actually, with the greatest respect, that is, remember at 160, having said that international law sets out reasonably determinate standards of conduct applicable between states, in our view there is no reason why the law of duress should not treat these as providing an appropriate test of illegitimate pressure. In my submission, that is a rather odd way round to put things. I mean, in my submission, firstly, the court didn't cite any authority, and one might say, well, one's starting here, well, this is uncharted territory, so maybe that's not a fair criticism. But far from there being no reason why this was not the appropriate test, there is every reason why it's not. They said there's no reason why it should not treat these as appropriate, being the appropriate test, but I would suggest there is every reason and why it's not appropriate. And we've been through the cases which really show that, and it would be a radical reshaping of the law if one goes down this route. Now, as it's worth noting that Ukraine's case, and this is the oddity about it all, is that they say it isn't part of their case that it's necessary to adjudicate on any question of international law. We'll obviously have to hear how that is put, but we simply don't understand how that submission can be made. And indeed, if that is right, Mr. Thank's submission should be that he can produce a revised version of his defence which crosses out all the references to international law. It's quite difficult to see how that would work. And so we set out in our case, I think, 7 reasons why the Court of Appeal was wrong. I think I've largely covered them, and I think I can probably move on. What I would, just before I move off that point, like to draw your attention to, which is relevant to this, is Ukraine rely on an article by somebody called Gelpern. It might just be worth turning it up. It's not in the authorities, it's actually in the evidence, and so it's in it's in App Part 2, Volume 5, the Appendix Part 2, Volume 5. And it's at page 10393.
Sorry, Mr. Howard, can I have the bundle again, please?
Yeah, sorry, it's the Appendix Part 2, Volume 5, probably something that we'd be referring to, but have it? Yeah, and it's page 10393, and the point that I just wanted to draw attention to, this is an article from something called by somebody called Anna Gelpern from Capital Markets Law Journal. You can see that 10381. The title is Russia's Contract Arbitrage. But the point that the author makes at page 10393, I won't read it out, but you can see it from the paragraph beginning as an alternative. The point that she was making is if the UK Parliament considers that Russia's conduct has been inappropriate, in other words, as a matter of political will, it could pass legislation, and she explains what the legislation would be, effectively preventing Russia, through the law Debenture, enforcing its rights on the notes. Now, the point is, that's entirely right. The UK Parliament, if it chose, could do that. The UK Parliament has not done that, and in my submission, that's a matter on the, as it were, for the executive to decide on, and insofar as the matters that Ukraine raises are, we say they are matters which are on the international plane, they're matters for the UK executive, and they're not matters with respect for the court. Now, in the time I have left, I want to turn to some submissions that Ukraine makes to try and get round these difficulties. So,
can I just ask you one thing?
Yes.
I mean, it's a possible response to what you've been saying is that some of these parts of the pleadings should be struck out or aren't effective,
yes.
whereas others are. Is that a possibility which is open to us? Or?
That was the point I was trying to make when we came back after the short adjournment. My primary submission is that the whole case is infected.
Yeah.
But if I'm wrong about that, and you said, for instance, your Lordship pointed to paragraph 18.7. Now, I say that standing on its own just isn't capable of constituting an unlawful threat. But if one said, well, we're going to read it generously, and what it's saying is that President Putin allegedly threatened to procure that banks would act in breach of their contracts I mean, it's a bit unclear to see how it would work. But let's say it's allegedly procuring breach of contract by Russian banks in their dealings with Ukrainian entities. That would be a plain vanilla case of economic duress that you're saying, I'm threatening to do something which is recognizable on the domestic plane. Now, in my submission, that's not a fair reading of the pleading, but if your Lordship said, well, that is, then that's all that would be left. In other words, one would have to isolate, and that's what I was trying to suggest, that one has got to engage with the pleading and see whether there is anything which is capable of being put purely as a matter of English law.
But insofar as there isn't, what then follows?
If there isn't, then we're entitled to summary judgment, as Mr. Justice Blair found.
Well, does that follow?
Yes, because there isn't a defence of duress. Because remember, that's why the distinction between the relevance and the suitability questions are important. If one concluded something was relevant but not suitable, you get into questions of what do we do next?
Yeah.
But if your conclusion is it's not relevant, like in cases like Al-Haq and Gentle, there's just no English law right engaged, so it's just an irrelevant averment.
Yes, yes.
So, my Lord, my proposition 11...
If on the other hand we took the view that there was a domestic foothold, but that the issues raised were unsuitable for judicial determination, then a stay would follow, I think.
Well, we are not... our submission would be you shouldn't get there.
No, I
The
understand.
Court of Appeal's approach was no, they weren't going to stay it, that they would go on to decide these issues. And so that's the issue that the court would have to determine.
Yeah.
Now, my next proposition is that Ukraine, proposition 11, Ukraine cannot get round this by saying that, which is what they say, that international law is being used as a guide to or to inform the common law. And what they're trying to do there is, to some extent, I think they are retreating from the way in which the Court of Appeal put it. But quite simply, this is just another way of labelling. So, as a matter of substance, Ukraine is asking the English court to apply international law as part of English law in determining whether there has been duress. And on Ukraine's approach and the Court of Appeal's approach, what is actually happening is a new rule is being created specifically in relation to states, in relation to duress. But whether you call it incorporating or developing or informing the common law, it's all a distinction without a difference. And Lord Sale's paragraph 160 actually is perfectly open about what it's doing. It's applying the international law. And the Ukraine themselves cite in support of this argument the dicta of Lord Mance in KU, and those dicta are actually concerned with incorporation. It's paragraph 144 of KU. Now, at this point, I should just address a slightly more esoteric argument that Ukraine have made, and it's this. They seek to rely on the rules applicable to tort. And so they say there is no difference between using international law to determine whether the conduct of one state to another was unlawful or illegitimate, and looking to foreign rules and standards in assessing liability and tort. That's their case at paragraph 49. So the analogy they seek to draw is that you might look at an international accountancy standard to see whether an accountant was negligent. Now, the simple answer to this is that tort is completely different. Its choice of law rules are completely different. So what Ukraine tries to do is they try to rely on Article 17 of the Rome II regulation, which is entitled Rules of Safety and Conduct, which provides that in assessing the conduct of a person claimed to be liable, account shall be taken of the rules of safety and conduct which were in force at the place and time of the event giving rise to the liability. Now, there are a number of reasons why this is misconceived. First, and critically, the law of duress has gone down a different road to the legal standards for the law of tort. And you saw that in Dim School, where the House of Lords made it clear that the relevant standard is an English law standard for an English law contract. And that point also comes out of Article 10 of Rome 1, as explained in Sapporo, that we looked at. The area of law that my friends are relying on in Rome 2, you have to set in context. Article 4.1 of the Rome 2 regulation provides that the choice of law in tort is usually determined by the place where the damage occurs. But that is subject to various exceptions. One exception is if both claimant and defendant have their habitual residence in one country, then the law of that country shall apply. But it's then that Article 17 kicks in, and the purpose of Article 17 is that essentially it's looking at traffic accidents, and where the Article 4 has taken you to the both parties are resident in one country, but the accident occurred in another. So say you had two English people who happen to be in France and they have an accident, you still take account of the rules of the road in France, although you're applying English law. None of that's got anything to do with duress. And all of this, the approach would require disregarding Dim School and the rules in Rome 1. So that's, at least at this stage, all I want to say about that. Now, a point that Ukraine make, which is that they say, and I think this is how they seek to get round the international law element, they say that the question is, well, this is my proposition 12. I say Ukraine can't get round the problem by contending that the alleged threats to breach international law carry with them a threat to breach English law standards of lawful or otherwise illegitimate conduct. And what Ukraine seeks to do, and I'm sure this is what we're going to hear from my learned friend, seeks to liken its case to a case of duress to person or duress to goods or economic duress, so that it asserts that the facts of Russia's conduct as pleaded, they say, plainly amount to duress, both physical and economic. Now, the problem with this is very simple. If we just break it down, duress to person means a threat to harm a person in a way that English law regards as unlawful or illegitimate. And you get that from Barton and Armstrong, which we don't need to turn up. But the simple point is, it wouldn't be duress for a police officer to threaten to arrest somebody on a proper basis. Equally, duress to goods means a threat to harm somebody's goods in a way that English law regards as unlawful or otherwise illegitimate. So again, it's not duress for, say, HMRC to threaten to impound goods if duty lawfully due is not paid. And economic duress, you've already seen, must be a threat to do something that English law regards as unlawful or illegitimate. So all that Ukraine has alleged is, we've seen, breaches of international law. Now, there seems to be a suggestion that if we take the supposed threat to use unlawful force as in breach of customary international law, that can be repackaged by Ukraine as a threat to persons or property. Now, that argument would amount to saying that any state that goes to war or threatens to go to war is doing something which is unlawful as a matter of English law, because the consequence is that people might be injured as a result. So in other words, all the cases that we've looked at about Article 2.4 and the customary international law prohibition on the use of force simply can be got round on Ukraine's argument by saying, oh, well, that would amount to injuring my citizens or something like that. Now, these sort of arguments were considered in Gentle, which you have at Authorities 2, tab 13. Because of the shortness of time, I won't turn it up, and we've largely looked at it. But at paragraphs 8, 13, 22, 43, 57, and 65, consideration is given to whether these sort of arguments, where there it was being said the UK government was going to put at risk the lives of UK servicemen, whether that somehow was a way of getting round the problem, and it wasn't. Lord Sumption, in the passage we looked at in Belhage, specifically addressed that point. You remember he said that if a foreign state deploys force in international space or the territory of another state, it would be extraordinary for an English court to treat these operations as mere private law torts giving rise to civil liabilities for personal injury, trespass, conversion, and the like. So my learned friends at paragraph 33 of their written case put forward various hypothetical examples of things which they say would constitute threats under English law. Now, a number of them are simply threats which on their face are to do something which English law would regard as unlawful. For instance, threatening to assault somebody or threatening to torture them or kidnap them without any lawful justification. So they might raise an arguable defence of duress. The suitability question may or may not be engaged. But you have to look at what it is that is alleged. So their paragraphs 33.1 to 3, as I say, appear to be threats simply to do things which would be regarded as unlawful under English law, whereas paragraph 33.4 is something which is raises the issues in this case, which is whether or not breach of use of force, it's contrary to international law, is something that the English court can take cognizance of, and I've explained why it can't. Now, you'll be pleased to know I've almost finished in my propositions. The next one is a very short one, proposition 13, which is that the trustee does not seek to immunise states from any applicable standard of conduct of English law. That's Ukraine's submissions are replete with that suggestion. We are not seeking to do that, and there's a short answer. The question is whether Ukraine has any proper case that the Russian Federation has made a threat which engages and breaches any English law standards. In our submission, it has not. So that brings me to the final point I need to consider, which is the public policy exception. So it's my proposition 14 is that the public policy exception to foreign act of state has no application in the present case. Now, the public policy exception allows claims that do have a domestic foothold to be determined, even though the claims would otherwise be non-justiciable in the sense of the suitability question. What they don't do is permit an arguable domestic law claim to be created where it does not otherwise exist. And the Court of Appeal appeared to recognise this at paragraph 156, in that they recognised the public policy exception as no logical application in the context of the relevance question. But Ukraine relies on three cases, two very well known, one less so. The two well-known cases are Kuwait Airways and Oppenheimer, and then they also rely on a case called Boxalis. Can I quickly, but in my last 20 minutes, deal with those? And the one they place most reliance on is Kuwait Airways. And what they seek to do, they did below and they seek to do here, is to try and draw an analogy with Kuwait Airways. And once one properly understands Kuwait Airways, there is no analogy to be drawn. Kuwait Airways is in the bundles at volume 2, tab 8. And it is page 589. And this decision of the House of Lords, I'm sure, again, is fairly familiar. One will remember that in the first Iraq War, what had happened was Iraq purported to annex Kuwait. It seized aircraft in Kuwait, had them flown back to Iraq, and then passed a resolution transferring the ownership of those aircraft to IAC, Iraqi Airways. It's very important to remember that the relevant, the reason all of that was relevant is the tort of conversion, which was the basis of the claim at this stage, was for conversion which had taken place in Iraq. And the question for the House of Lords was whether or not it should recognize the Iraqi decree that provided that KAC, Kuwait Airways, had been deprived of title to the aircraft. And a further, not complication, but the claim was in tort, and at the time the double actionability rule applied. So the question at issue was whether the acts were wrongful in Iraq to where the aircraft had been moved, and that depended on who owned the aircraft. As I say, Resolution 369 divested them of KAC of ownership. So the question was whether that resolution should be treated as valid. Now, ordinarily, a rule of private international law would apply that the English courts would respect the exercise of jurisdiction by a foreign state in relation to property within its own territory. That's a point made by Lord Nichols at paragraph 13 and Lord Hope at paragraph 135. But the point in that case was that Iraq's conduct was a flagrant and universally condemned breach of international law, as reiterated on numerous occasions by the Security Council, the United Nations Security Council, and indeed not disputed by Iraq. So that on the facts of that case, the court considered that the relevant laws should not be recognized as contrary to English public policy. So, and that you'll see all of that if I can just give you the paragraph references. At paragraphs 20, 22, 26 and 29 of Lord Nichols, and 107, 113 to 115 of Lord Steyn, and 139 to 140 and 149 of Lord Hope. Now, it was critical in Kuwait Airways that on the facts no question of adjudication of international law arose. Firstly, because Iraq's conduct had been condemned by the United Nations Security Council, and United Nations Security Council resolutions, as the court knows, are binding on all member states. It's explained by Lord Hope at paragraph 23. That meant it was impossible, as a matter of international law, for any state, including the United Kingdom, to dispute the illegality of Iraq's conduct. And in accordance with that, Iraq, the very state that was alleged to have acted contrary to international law, itself accepted that its conduct was contrary to international law. And that you see at paragraphs 26, 113, and 140, and 149. And so the existence of the resolutions placed clear and direct obligations on all member states pursuant to Article 25 of the Charter not to do any act which might constitute an indirect recognition of the annexation. So there was, in effect, a direct order to the United Kingdom by the international community not to recognise the relevant Iraqi laws, and indeed to do so would be a breach of the UK's obligations under the Charter. See paragraphs 29, 114 and 146. And so the reason I stress all of this, that is what the House of Lords meant by breach of international law being flagrant and universally condemned. So where a breach of international law has been established in that way, there's no requirement for adjudication because it's impossible for the court, in applying the acknowledged and mandated position, to be trespassing into areas of high policy, which are matters for the government or to embarrass the government. Now, it's inconceivable that if there'd been a dispute about the legality of Iraq's use of force or Iraq's conduct in Kuwait Airways, that the House of Lords would have considered it appropriate to determine the dispute. And that would be particularly problematic in a case where the UK executive had said nothing, but it's even more problematic where it has said something, because if the UK executive has said something, I mean, for instance, in this case, reliance is placed upon the UK executive having said things not about the threats that were allegedly made in this case, but about Russia's conduct in Crimea. But what potentially would be embarrassing is the court going into these matters and the court reaching a conclusion which was contrary to that which the executive had reached. Of course, in Kuwait Airways, that couldn't happen because of the Security Council resolutions. And if one just casts one's mind back to cases like Gentle, where and CND, which concerned the legality of the United Kingdom and its allies going to war in Iraq, it's absolutely clear that not only did the obligations matters on the international plane, but the English court would not venture into deciding whether the UK government had acted lawfully in international law in determining to go to war. Similarly, in Al-Haq, the court couldn't consider the legality of Israel's conduct. And if the test was simply one of some concept of flagrancy, it's difficult to see why the courts were not willing to adjudicate on the disputes in those cases. If you take Gentle and CND, there was clearly a substantial body of public opinion, and indeed informed opinion, that the United Kingdom government had acted in breach of international law. But for the courts to rule on that would be usurping the role of the executive. In Al-Haq, the ICJ had already determined that Israel's conduct in building a wall was unlawful. There were no UN Security Council resolutions against Israel. And again, rather similar to this case, it would be said, critics might say, well, the reason there's no UN Security Council resolution is because the United States, as Israel's ally, has exercised a right of veto. But it's not for the courts to start examining why the UN Security Council has not condemned things. That again would require the court to go into political matters and also overrides the whole foundation of the United Nations Security Council, which is that the permanent members have a right of veto, and that is what it means. It's for them to exercise, and it's not for an English court to, as it were, go into why they have. Now, and if it were legitimate for a court to determine whether there was a breach of international law, whenever a breach was said to be flagrant, then it would always be necessary for the court to go into the issues. Because you'd have to first decide whether there was a breach, then you'd have to decide whether it was flagrant, and the exception would then end up swallowing the rule. Now, Kuwait Airways is a relatively straightforward case where one can see why the court disapplied the usual private international law, recognizing disapplying the usual private international law rule, recognizing an Iraqi decree on the facts of that case. Oppenheimer is rather similar. Again, the court will be very familiar with that which concerned Nazi laws by which certain German Jews were stripped of their German nationality. The case is at Authorities 13, tab 115, MS 5079. Because I don't have time to turn it up, but the critical point in that case is that the relevant Nazi laws were acknowledged to be ones which were entirely contrary to human rights. And although they were laws which were passed in Germany, which one would expect, again, normally under the rule of comity, that you would recognize, it was disapplied because of the grave breaches of human rights. But none of that is of assistance in relation to this case, where what one is trying to determine is whether rules of international law should constitute the relevant standards of conduct in determining whether there is arguably a breach of English law standards of conduct for the purposes of the law of duress. And there's nothing in these cases, or there's nothing in this case, rather, that permits the rules of international law relied on to be incorporated in English law, whether as a standard of unlawfulness or of otherwise illegitimate conduct. Now, the final case that my friends rely on is a case called Royal Boxalis, which is in Authorities Volume 3 at tab 17 at MS 1149. Perhaps rather than asking you to turn it up at this stage, I would simply say this to you. This was a plain vanilla case involving duress to persons and goods. It has absolutely nothing to do with international law. Perhaps if I can just leave it on that basis, and we'll see what my friend makes of it. And so, though I think I promised that I had completed my propositions, I do in fact have two more, but they're both very short. Proposition 15 is that if the international law rules on which Ukraine relies are irrelevant, there's no basis for ordering a stay. So that's it. I don't need to develop that. I think it's common ground. And the final proposition, number 16, also the conclusion, is that the pleaded allegations were incapable of giving rise to a defence of duress as a matter of law. Accordingly, the trustee was entitled to summary judgment on this issue. And as I said earlier this afternoon, I say submit on a proper reading of the pleading, it is entirely based upon breach of international law. But if your lordships were against me on that construction of the pleading and said there was any part of it which was not dependent on international law, then the case could only continue in relation to that allegation, which would be, as I say, I suggest that is wrong, but that is my fallback position. So with 3 minutes to spare, those are my submissions.
Could I take one of the minutes? Mr. Howard,
Yes.
going back for a moment, you referred us to Belhadge, Lord Newburger's formulation at paragraph 123.
Sorry, I can't quite-
You referred us to Belhadge
Yes.
and to Lord Newburger's formulation
Yes.
of the principle at paragraph 123, and also Lord Sumption at 234. No need to go back to them. In each case, they emphasised that what was in issue was the ruling on the lawfulness of the conduct of the state. Now, as I understand it, you're suggesting that that should be extended to cover the questions of legitimacy if the net of the duress defence is cast more widely.
In my submission, it's not extending what they're saying. What I'm saying is you have to look at that principle which they've set out there, which is sorry, can I go back a stage? What, of course, they're dealing with in Belhadge is the dicta are all about the foreign act of state doctrine as an area that we don't go into.
Yes.
But we're concerned with I've already made the submission that in the relevance question, you have to consider suitability. So when one's considering the relevance question, if you apply what you see in Lord Newburger and Lord Sumption, you firstly say, well, plainly these matters are not part of English law, so you can't rely on them as unlawful. You then have to ask yourself, well, are they part of English law for some other purpose, i.e. for the purpose of saying this is otherwise illegitimate? And in my submission, exactly the same reasoning as you see in those dicta, applies whether you're saying I'm asking it for the purpose of whether this is part of English law for the purpose of an allegation of unlawfulness or part of English law for an allegation of otherwise illegitimate conduct.
Yes, the United States Supreme Court in Kirkpatrick seemed to confine the US Act of State doctrine quite narrowly to questions where it was necessary to rule on the legality of the conduct.
But of course, the way the Lord Sales has in the way the Court of Appeal has put it, that is exactly what you're actually doing.
I see.
I mean, you might put a different label on it, but the thing is, you've got to remember where he starts is you say under the law of duress you can apply a morality or social standard, but then he recognises you don't have morality or social standards in relation to states. States just operate on the international plane. I mean, other than if they do things which normal people can do. But interstate relations are not matters which are part of what one would normally call social interaction or morality. So as what Lord Sales then says is, well, we've got a standard in international law, and we can just use that. But all that is saying is I will determine whether or not you were in breach of international law or you were threatening a breach of international law as a basis for saying that is otherwise illegitimate. So it is just using a different label but getting to exactly the same result. And in my submission, of course, cases such as Kirkpatrick or Belhadge and the dicta, people haven't specifically had to deal with this issue. But one's then got to apply the ratio and the rationale of the act of state doctrine to this type of situation. In my submission, there's only one sensible answer.
Thank you.
I mean, as I understand it, you're saying that the task for the Court of Appeal has set itself is to decide whether Russia has broken its obligations under international law.
Yes.
And they've done that because they're treating its obligations under international law as the relevant standards of behaviour for the purposes of the English law of duress.
Yes. I mean, and that's ultimately, I mean, if I can turn around my Lloyd Jones question, what you're actually then doing is extending the law of duress to say, for the purposes of the law of duress, where we have states, we will go into these questions. And in my submission, that is what is completely unwarranted.
Presumably, I mean, as I understand it, your argument is that the objections we've seen in the authorities to domestic courts deciding whether there's been a breach of international law apply with equal force if you're deciding whether there's been a breach of international law for the purpose of deciding whether acceptable standards of behaviour for contractual purposes have been complied with.
Exactly.
Thank you very much indeed. Forward to hearing Mr. Thankey tomorrow morning in reply. Mr. Jones, do you follow? Very well then. We'll adjourn. Thank you.